Estate planning mistakes can cost your family time, money, and unnecessary stress. But the good news is they're completely avoidable. Today, I'm walking you through the most common and costly estate planning blunders and how you can make sure your loved ones are protected. I'm John Farrell, an estate planning attorney in Georgia. I help families create solid estate plans that minimize taxes, avoid probate, and protect their legacy. If that sounds important to you, hit like, subscribe, and turn on notifications so you don't miss out on future estate planning insights. A lot of people think estate planning is just for the ultra-wealthy or retirees, but that couldn't be further from the truth. If you own a home, have kids, or even just a bank account, you need a plan. Without an estate plan, state laws will dictate who gets your assets, and that may not align with your wishes. Probate fees, legal costs, and taxes can eat up a significant portion of your estate if you don't plan ahead. Family disputes over money or guardianship decisions are more common than you think, and they can destroy relationships. Let me share a story. A couple in their 40s had a young daughter, but never got around to doing their estate planning. When the husband passed away unexpectedly, the wife thought everything would go to her automatically. But because he had assets in his name alone, she had to go through probate court, spending over a year and thousands of dollars just to gain access to his accounts. This situation could have been easily avoided with a simple estate plan. Now, let's dive into the biggest estate planning mistakes I see people make and how to avoid them. Blunder number 1. Failing to update your estate plan regularly. Your estate plan isn't something you do once and forget about. Laws change, your assets change, and your family situation changes. If your plan is outdated, it might not work the way you intended. Here's when to update your estate plan. Marriage or divorce, birth of a child or grandchild, death of a beneficiary or executor, major financial changes such as buying or selling property, inheritance, moving to a different state. I always recommend reviewing your estate plan every 3 years, even if nothing major has changed. A quick review can ensure your wishes are still accurately reflected. Blunder number 2, not naming or updating beneficiaries. Here's something a lot of people don't realize. Your will does not control everything you own. Many assets, like life insurance, retirement accounts, and sometimes bank accounts, pass directly to the named beneficiaries on file. If you don't name a beneficiary or your listed beneficiary has passed away, your assets may go through probate. If you've remarried but forgotten to update your life insurance, your ex-spouse might still inherit your policy. Make sure you check your IRA, 401ks, life insurance, and payable on death accounts regularly to confirm they're up to date. Blunder number 3, not considering the impact of taxes. Taxes can take a serious bite out of the wealth you leave behind if you don't plan properly. While Georgia doesn't have a state estate tax, federal estate taxes, capital gains taxes, and income taxes on inherited retirement accounts can still impact your family. A well-structured trust can minimize estate taxes and keep more money in your family's hands. If you're passing down a house, consider the impact of capital gains taxes on your heirs. Inherited IRAs now have strict withdrawal rules. Your heirs might face hefty income taxes if they're not careful. Before you create a plan, you need to understand what you own and how you want to distribute it. Here's how to start. Step 1. Identify your assets and liabilities. Do you have real estate, bank accounts, investments, life insurance, or retirement accounts? Debts, loans, mortgages, anything that needs to be accounted for. Step 2. Determine your beneficiaries and distribution plan. Who do you want to inherit your assets? Do you want to set any conditions like protecting a child from irresponsible spending? What happens if a beneficiary predeceases you? Step 3. Choose the right estate planning tools. Wills, they ensure your wishes are legally documented. Trusts, avoid probate, minimize taxes, and protect your legacy. Powers of attorney, assign someone to make financial and medical decisions if you become incapacitated. Using the right tools ensures your estate is distributed smoothly, efficiently, and according to your wishes. Many people turn to do-it-yourself estate planning tools to save money, but these one-size-fits-all documents often do more harm than good. Estate laws are complex, and a small mistake can have huge consequences. Why work with an estate planning attorney? They ensure your documents are legally sound and comply with state laws. They help you avoid probate and unnecessary taxes. They provide guidance for complex family situations like blended families, special needs plannings, and things of that nature. Finding the right attorney is key. Look for someone with experience, great client reviews, and a focus on estate planning, not just a criminal lawyer that does estate planning on the side. At the end of the day, estate planning is about protecting what you've worked for and ensuring your loved ones are taken care of. A well-structured estate plan gives you peace of mind knowing your family won't have to fight over assets. Your children's financial future is secure. Your wishes will be honored exactly as you intended. Think of estate planning as your final love letter to your family. It's your way of making sure they're protected and that your legacy lives on. If you don't have an estate plan, or if yours is out of date, don't wait. Click the link in the description to schedule a consultation, and let's create a plan that gives you and your family peace of mind. And if you found this video helpful, hit like, subscribe, and drop a comment below with your biggest estate planning questions.